Mr. Subramanian.
Thank you, my lord. My lords, I wish to begin by saying that in constitutional arguments, there can be multiple approaches.
From London, my lord. London is behind all these problems.
May I only correct my friend, my lord, I don't live in London. I'm only in the suburbs. My lord, having said that, there are, my lord, multiple approaches. One, my lord, is what we call traditionally the historical argument. The second, my lord, would be a textual argument. The third is a doctrinal argument. The fourth is prudential, and the last is structural argument. Well, these are all well-known methods of interpreting a constitution. These are broadly, my lord, the topology of constitutional arguments. In this case, whatever approach, my lord, we may adopt, the end result will be the same. Whichever way we proceed to look at this matter, there will be...
Who are you appearing for in this batch of cases?
I'm appearing, my lord, so if I may just point out to it, I'm appearing in writ petition civil 1104 of 2019.
And petitioner there?
Yes, my lord, there is a petitioner, Muzaffar
Iqbal
Khan. Yes. My lord, my written submissions are also on your lordship's record.
Yes, Mr. Bhatt.
So, my lords, I'm going to urge for your lordship's consideration 4 important propositions. The first is the Constitution of India and the Constitution of Jammu and Kashmir speak to each other. They exist together. And their complementary existence is the quintessence of the relationship between India and Jammu and Kashmir. The second.
So they speak to each other and
Yes.
complementary
And
existence.
they're complementary constitutions. With respect to Justice Nariman in one of the judgments, he called it subordinate. I think the word is slightly inapposite. I would say complementary.
Yes.
The second, my lord, is that Constituent Assembly by its very definition is a primary assembly which is vested with this extraordinary task of framing a constitution. That is why, my lord, the amending power is always called a derived power. An amending power, a power to amend a constitution, is always called a derived power. And here, my lord, we have 2 constituent assemblies. The Constituent Assembly of India, and we also have, under the Constitution, recognized by the Constitution, a Constituent Assembly of Jammu and Kashmir. This is the second. But what is its implication? I'll deal with it. Then the third, the impugned orders, that is CO272 and CO273, in sum and substance do away with the Constitution of Jammu and Kashmir. That, my lord, is impermissible. It is not authorized. The last is about this expression people. Here, my lord, people have both the sense of being persons, but in the constitutional context, they have a legal and juridical existence.
Yes.
If I may now, my lord, submit. My lord, Honorable the Chief Justice yesterday made a very important observation, and it is perhaps a critical observation that in any representative democracy, we must look for expression through the institutions under the Constitution. And, my lord, I'm going to urge your lordships to consider that the expression Constituent Assembly and Legislature of a state are both institutions recognized under our Constitution. I will submit, my lord, that the basic structure which your lordships have to discern in this case to determine whether there could be any abrogation of it will be deduced both from the Indian Constitution and the Jammu and Kashmir Constitution. I will also urge your lordships to employ.
Just yeah, 1 minute. 1 second. Yes, Mr. Brown.
I will urge your lordships to apply what is called the degree test or the effect test applied by Chief Justice Kapadia in a case called Glenrock. And it is by applying that test we assess the extent of abrogation. Most importantly, my lord, our Constitution recognizes asymmetric federalism. And the purpose of asymmetry is to take note of special conditions and special needs of people. Now, my lord, the great colossus, Dr. Ambedkar, introduced the Constitution, and his introductory speech had two themes. That speech, my lord, is available for your lordships in document volume 8. And in that opening speech, Dr. Ambedkar speaks about the Indian Constitution being federal. And he also says that people who live in a state can be given special rights, special privileges. There was another question which I think I heard my Lord Justice Gavai mention, which was there were also princes who merged their states at the time of the Constitution. There were agreements. What was the status of those agreements? Could they not be abrogated? And my Lord, there is some answer which needs to be offered to that question. It's a very important question. Jammu and Kashmir was not like any other state at the time of accession. It was not like any other state. And I'll give your lordships 3 reasons. The first, Jammu and Kashmir was a state which had its own constitution prior to the act of accession. They had a constitution of 1939. Two, the accession by the Maharaja was qualified because people were still in the process of making up their mind. What, my lord, the Indian Constituent Assembly did is that just as they felt a decision can only be taken by the people of a country, they thought it's appropriate and necessary that the will of the people is ascertained. My lord, that is the first hallmark of this case. What did the Constituent Assembly and later in our constitutional text, proffer to do. They maintain the highest sense of democracy and respect. Just as we are enacting and giving unto ourselves a constitution, we must give that constituent assembly to determine their future. And that, my lord, is the reason why in draft Article 306A, which was introduced by Mr. Gopalaswamy Iyengar, spoke about the Constituent Assembly of Jammu and Kashmir taking a decision. Now, my lords, the entire controversy or dispute has been presaged, if I may say so, on one misunderstanding. Namely, there is a unilateral exercise of power possible by the President under Article 370. This is how, my lord, we've looked at the provision. Now I'm going to show to your lordships, it is exactly the converse.